What if the very body that was created to guarantee speedy justice ended up in a decade-long legal fight? A fight that went all the way to the Supreme Court, which then declared the very constitutional clauses that created it void. Just imagine that. A massive constitutional amendment, the 42nd no less, is used to totally reshape administrative justice. And then the highest court in the land just steps in and says, no, not like this. It was a powerful check, reasserting that no amount of efficiency is worth sacrificing the core structure of our judiciary.
That's not just a history lesson. It's the constitutional battleground that you absolutely have to understand today. This whole struggle revolves around one thing: tribunals in India. For any serious UPSC aspirant, mastering where these bodies fit in, Articles 323A and 323B, and seeing the limits the Chandra Kumar judgment put on them, it's not optional. It's really the key to unlocking those separation of powers questions in mains.
Okay, so let's unpack this critical chapter. We're going beyond just the definitions and into that deep structural conflict. Welcome to the deep dive. This analysis is specifically for you, the aspirant, and we're using that solid foundational framework from texts like M. Laxmikanth's 8th edition, all filtered through the kind of high-utility analysis you get from Simplified UPSC by PPP. And before we jump into the articles, just a quick word. If you find this kind of detailed analysis useful, content designed to cut through all the noise, please take a second to like this content, subscribe, and maybe consider joining our paid membership on YouTube. Your support is truly what allows us to keep bringing you this level of in-depth analysis. And a massive shout out to all of our existing members. Your contributions are what sustains this whole project. And please don't forget to share your valuable comments below.
And remember, to really maximize your prep, we have resources for you. There are free notes covering everything we discussed today, along with essential practice PYQs, all on our Telegram channel. And for our legend YouTube members, we've got premium notes, extra PYQs, and detailed model mains answers waiting for you over on our Discord. Definitely use those tools. They're there to help you apply what we're about to talk about.
Right. So our mission today is laser-focused. We are distilling the absolute essential knowledge on tribunals. We're focusing on their constitutional foundation, their structural flaws, and the ultimate judicial reaction. We need to know not just what Articles 323A and 323B did, but critically, how the judiciary pushed back.
Specifically through the Chandra Kumar case from 1997, understanding this connects directly to those really complex mains questions on the separation of powers and, the inviolability of our entire constitutional machine.
So let's start at the very beginning, at the foundation. In the mid-1970s, what was going on with the traditional courts that made creating this whole parallel system of tribunals seem like such an urgent, almost revolutionary idea?
Well, the crisis was. It was coming from a few different directions. First, just sheer volume. The number of disputes, especially those involving government employees, promotions, seniority, disciplinary actions, they were just drowning the high courts. These courts were set up to handle big constitutional questions, serious criminal matters, not to be day-to-day HR departments for the government.
Right. They weren't grievance redressal forums.
Exactly. And the second thing was expertise. Administrative law, tax disputes, environmental issues. These things require specialized knowledge. A generalist judge, brilliant as they may be, might not have that deep technical understanding. And the traditional court procedure, with its strict evidence rules, was just too slow and too expensive.
So the goal was basically triage. You take these specialized high-volume cases and you shunt them over to a new system that's built for speed and technical competence.
Precisely. And the 42nd Constitutional Amendment Act of 1976 was the legislative vehicle for this. It inserted a whole new Part 4-VA into the Constitution. And this part had two key articles, Article 323A and Article 323B. Now, these articles didn't create the tribunals themselves, but they gave the legislature the power to create them. They gave these new bodies constitutional legitimacy.
Okay, let's break those two down, starting with the one that affects the most government employees, Article 323A.
Right. Article 323A is incredibly specific. It's very narrow. It gives Parliament the power to set up tribunals for disputes that relate exclusively to administrative matters.
And what does that mean in practice?
It means disputes and complaints about recruitment and conditions of service for people in public service. So affairs of the union, a state, any local authority. It's all about the internal machinery of government employment.
And when Parliament used this power, the result was the Administrative Tribunals Act of 1985. So what did that act actually set up?
The 1985 Act created the two main structures we know today. The Central Administrative Tribunal, or CIDE, and it also enabled the creation of state administrative tribunals, the SAT.
Okay, let's take the CAT first.
The CIT is based in Delhi, but it has benches all over India. And it has what's called original jurisdiction. It covers recruitment and service matters for all central government employees. We're talking all India services, civilian employees in defense, the whole gamut. And it covers all service disputes. This means you go straight to the CIT. You don't go to a lower court or even a high court first.
And that phrase, original jurisdiction, is so important here. It means the tribunal is the first stop, right? And it's where the evidence is heard for the first time.
Absolutely. The CIT is the primary judicial forum for these matters. Now, when it comes to the state administrative tribunals, the SATs, the mechanism is a little more complex. And this is a favorite area for, those tricky UPSC questions.
How so? What's the complexity?
Well, while it's Parliament that makes the main law, the central government only establishes a SAT if there's a specific request from the state government involved.
Ah, okay. So it's not imposed from the top down.
Exactly. It's a really subtle but crucial point about federal cooperation. And once it's established, the SAT does for state employees exactly what the CIT does for central employees. It exercises that same original jurisdiction over all their service matters.
Now, you mentioned that what really makes these bodies different from courts is their composition. Can we dig into that a bit, specifically the appointment process, because that became a huge point of conflict later on?
Yes, the composition is fascinating because it shows you the original intent, that focus on specialization. These tribunals are designed as multi-member bodies. They often have both judicial members, people with qualifications like a high court judge, and also administrative members.
And those are the senior bureaucrats, retired secretaries, and so on.
Right. The idea was to combine that judicial mindset with real-world administrative experience, to bring someone in who understood how government file and service rules actually work.
Which on the surface makes perfect sense.
It does. But this dual nature immediately raised red flags about judicial independence. And for the SATs, the appointment structure is really telling. The chairman and members are appointed by the central government. Now, these appointments are vetted by a search-cum-selection committee, and that committee is chaired by the Chief Justice of the High Court of that state.
So there's an attempt to bring in some judicial oversight.
An attempt, yes. But the final appointing authority is still the executive branch, the central government. And critics immediately jumped on this. They argued that having the executive, the very entity that the employee is suing, control the appointments, well, it fundamentally compromises the impartiality of the whole setup.
Right. How can a tribunal be truly independent if its members, especially the administrative ones, owe their job, and maybe their next one, to the government they're supposed to be holding accountable?
That was the structural fault, and that was the core problem.
Yeah.
The issue of executive dominance over appointments and even infrastructure is a theme that just keeps coming up, driving judicial intervention even today.
Okay, so that's 323A, tightly focused on administrative matters, legislated only by Parliament, leading to CCATs and SATs.
Yeah.
Now let's pivot to Article 323B. This one is for other matters, and it sounds much, much broader.
It is. Article 323B is the constitutional framework for specialization across almost every other area of governance. And this is the critical distinction from 323A. It allows the appropriate legislature, which could be Parliament or a state legislature, to set up tribunals for a whole range of subjects.
And that term appropriate legislature just depends on whether the subject is on the union list, state list, or concurrent list, right?
Precisely. If it's a union or concurrent list subject, Parliament acts. If it's a state list subject, the state legislature has the power. And the Constitution itself lists several domains where this can be done. Things like taxation, which is why we have bodies like the Sestat for customs and excise tax, also foreign exchange and import-export, industrial and labor disputes, even politically sensitive areas like land reforms, rent and tenancy, even elections to parliament or state legislatures, though that's usually handled by high courts, the power to create a tribunal is there.
The scope of 323B is just huge. It covers all the major economic and civic friction points of a modern state. This must be where bodies like the National Green Tribunal, the NGT, get their authority from.
The NGT is a perfect example of 323B in action. It was set up much later by the NGT Act of 2010, but that act drew its power from the environmental subjects covered under 323B. And these tribunals often have highly specialized members. You'll find environmental scientists on the NGT, for example, which really emphasizes the technical nature of the justice they're supposed to deliver.
So just to crystallize the contrast for everyone listening, 323A versus 323B, what's the core conceptual nugget?
Okay, there are three main differences you have to remember. One, scope. 323A is singular, just administrative service matters. 323B is plural. It covers a whole list of different subjects.
Right.
Two, legislative power. 323A can only be enacted by Parliament, period. 323B can be enacted by Parliament or a state legislature, depending on who has jurisdiction over the subject.
And the third.
Third is the structure. 323A lets you create only one central tribunal, the CAT, and then multiple SATs. 323B, on the other hand, allows for a whole hierarchy of tribunals for each of the different matters it lists.
So the intent was clearly to build a system of justice that was faster, more accessible, and used specialized knowledge. I mean, on paper, it sounds like the perfect solution to the backlog problem.
On paper, it was revolutionary. The 42nd Amendment carved out these special zones for justice. But the problem, the constitutional crisis, didn't come from creating specialized justice. It came from the attempt to wall it off, to isolate it from the traditional judiciary.
And that attempt to create a walled-off specialized system is exactly what led to the huge constitutional showdown we have to talk about next.
Yeah.
Because when you create a new system of justice, you are inevitably challenging the authority of the old one. Okay, this is where the high-stakes conflict really kicks off. We have to remember the context. The 42nd Amendment was passed during the emergency. This was a time of significant legislative efforts to consolidate power and, frankly, to limit judicial oversight. So this tension between tribunals and courts wasn't an accident. It was by design.
That is absolutely critical context. The goal wasn't just speed, it was finality. The original clauses in the Constitution were trying to create a totally self-sufficient, high-speed judicial circuit, a place where disputes were born, heard, and finished, all within the tribunal system itself.
And the main way they tried to do that was by cutting out the high courts,
Right.
excluding their power of judicial review.
Precisely. The original laws and the constitutional articles themselves, before the Supreme Court stepped in, had clauses that were meant to make the tribunal's decision final. Maybe, in some cases, you could have a direct appeal to the Supreme Court under Article 136, a special leave petition. But the big threat, the constitutional danger, was the exclusion of high court jurisdiction under Articles 226 and 227.
And why was taking the high courts out of the loop so dangerous, constitutionally speaking?
Because the high courts are designed to be the primary protectors of law and liberty in the states. Their writ jurisdiction under Article 2226 is deliberately broad. It covers not just fundamental rights, but also any other purpose. That means ordinary legal rights, things like your service conditions, a tax dispute, a land title. If you remove the high court's ability to scrutinize these things, you're removing the main constitutional check on arbitrary power by administrative bodies, and that includes the tribunals themselves.
So this built-in conflict, this battle between legislative efficiency and judicial oversight, it all culminated in the landmark judgment that defines tribunal law in India today. L. Chandra Kumar versus Union of India in 1997.
Yes. This case is non-negotiable for anyone preparing for the UPSC. The core question before the Supreme Court was this: did the power given to Parliament by Articles 323A and 323B actually allow it to exclude the jurisdiction of the High Courts and the Supreme Court over these tribunals?
And what was the Supreme Court's definitive answer to that?
The answer was a clear, resounding no. The Supreme Court struck down two specific clauses as unconstitutional and void. These were Clause 2-A of Article 323A and Clause 3-A of Article 323B. These were the exact provisions that tried to exclude judicial review by the high courts under Articles 226 and 227.
That is a pivotal moment. The court was essentially drawing a constitutional red line, saying that Parliament, even with its power to amend the Constitution, could not touch this essential power of the judiciary.
Exactly, and the court's reasoning was based on the basic structure doctrine. It ruled that the power of judicial review, the power of higher courts to review the decisions of all lower courts and tribunals, is an integral part of the basic structure of the Constitution. And what that means is that this power is immune from amendment. It can't be taken away.
So the L. Chandra Kumar ruling basically took the principle from Kesavananda Bharati that Parliament can't destroy the basic structure and applied it directly to the system of administrative justice.
Yes, it secured that foundational separation of powers. The court confirmed that the independence of the judiciary is non-negotiable. Parliament can create specialized courts, sure, but it can't create parallel judicial systems that are just islands unto themselves, totally unaccountable. The Supreme Court essentially treated judicial review like a safety fuse. You can rewire the house for efficiency, but you can't remove the fuse because then the whole system risks burning down from unchecked power.
So let's talk about the practical implications of this verdict. What did it actually change about how tribunals function day to day?
It fundamentally redefined their status. After 1997, tribunals are no longer seen as substitutes for the high courts. Instead, they function as courts of first instance. They still do the initial heavy lifting, the fact-finding, hearing evidence, making the primary decision, but their decisions are now always subject to judicial scrutiny.
And that scrutiny has to come from the High Court first. Can you walk us through the correct legal path now after 1997 if someone wants to challenge a tribunal's decision?
This is a crucial procedural point for aspirants to know cold. The hierarchy is now set in stone. First, the tribunal. The matter starts there. CAT, SAT, NGT, whatever it is. It has original jurisdiction.
Step 1.
Then step 2, the High Court. The person who is unhappy with the tribunal's decision must then go to the concerned High Court's division bench. And they do this using the writ jurisdiction under Article 226 or the supervisory jurisdiction under Article 227.
And only after that.
Only after the High Court has given its ruling can the matter go to the Supreme Court, usually through a special leave petition or SLP under Article 136.
You mentioned writ jurisdiction. For the listener who needs to understand the mechanics here, what does it actually mean to approach the High Court with a writ of certiorari or mandamus?
It means you are asking the High Court to review the legality and the procedure of the tribunal's decision, and not usually to re-argue the facts of the case. So a writ of certiorari is used to quash or cancel a tribunal's decision if the tribunal, say, went beyond its jurisdiction, or violated the principles of natural justice, or made a clear error of law. You're asking the High Court to pull up the record and check if the process was legal.
And mandamus.
Mandamus means we command. It's used to force the tribunal to do its legal duty if it has failed to, or to correct an error it's making. The key point is the High Court isn't retrying the whole case. It's acting as a supervisor, using its constitutional power to make sure the tribunal, which is a creation of a statute, acts strictly within the law and the Constitution.
That distinction is so important. The High Court is acting as a constitutional quality controller, not just another level of appeal.
Precisely. And the court also emphasized the role of Article 2297, the power of superintendence. High courts have this supervisory power over all courts and tribunals in their territory. It's another layer of control, ensuring fairness and efficiency.
So in the end, the L. Chandra Kumar verdict actually saved the tribunal system by integrating it properly into the Constitution, rather than letting it exist as this kind of parallel threat. But it didn't fix those underlying issues about appointments and independence, did it?
No, it only fixed the appellate structure, the criticism about composition, the presence of bureaucrats, the executive's influence in appointments. That actually intensified after 1997. The verdict decided where they report, but not who they are. And that tension continues to fuel legal battles even today, which is something we absolutely have to link to the UPSC syllabus.
We've laid out the constitutional framework and the big judicial fix. Now let's talk about the high utility insights for you, the UPSC aspirant. Why should a candidate care about the tiny details of a SAT selection committee beyond just memorizing it for a prelims question?
Because studying tribunals is like a direct case study in how core constitutional principles actually work in the real world. We're talking separation of powers, basic structure, even fundamental rights, all playing out in administrative practice.
Okay, let's start with fundamental rights. How does the technical law of administrative tribunals connect to something as profound as Article 21, the right to life and personal liberty?
The connection is incredibly deep, and it's been recognized by the Supreme Court itself through its broad interpretation of Article 21. The right to life has been held to include the right to livelihood. So when a government employee is wrongfully fired or demoted or their salary is withheld, their right to livelihood is directly threatened. The CAT and the SAT are the constitutional tools created to restore that livelihood through speedy justice.
So if a tribunal is slow or biased or just not independent, then the state is actually failing in its constitutional duty to protect the right to life.
Exactly that. When these administrative cases drag on for years, and many do, despite their mandate for speed, that delay is a denial of justice. And that in itself is seen as a violation of Article 21. Answering a mains question on the scope of Article 21 is much stronger if you can mention institutional mechanisms like tribunals and then critique their effectiveness.
Let's zoom out a bit for exam clarity and compare tribunals to other bodies. We often talk about bodies being constitutional, statutory, or executive. Where do tribunals really fit?
This is a point of clarity that's crucial. You have to look at the source of authority. Constitutional bodies are those that are created and detailed right in the Constitution itself. Think of the Election Commission in Article 324 or the CAG in Article 148. Their powers are fundamentally constitutional. Statutory bodies, which include these tribunals, are creatures of statute. They're created by an act of Parliament, like the Administrative Tribunals Act of 1985. But, and this is the key, that statute is enabled by a constitutional article like 323A or 323B. So while they have a constitutional backing, their day-to-day rules, their composition, their budget, all of that is governed by ordinary law, and that makes them more vulnerable to tinkering by the legislature and the executive.
Which means Parliament can amend the Administrative Tribunals Act much more easily than it could, say, fundamentally change the structure of the Election Commission. That would need a much tougher constitutional amendment.
That is the core distinction. And the ease with which the government can modify the structure and selection process of these statutory tribunals is exactly why the judiciary has been so watchful in the years since L. Chandra Kumar. The courts are constantly on guard to ensure these legislative changes don't strip away the judicial character of the tribunals.
Okay, let's connect this to the wider scope of judicial power. We mentioned how the High Court's jurisdiction under Article 226 is wider than the Supreme Court's under Article 32. Why does that technicality matter so much in the context of reviewing tribunal decisions?
It matters because most disputes that go to tribunals are about legal rights, not necessarily fundamental rights. For instance, a fight over a tax assessment or a land title is a dispute over an ordinary legal right, something protected by a statute, not directly by the Constitution.
Right.
The Supreme Court's Article 32 is only for enforcing fundamental rights. But the High Court, under Article 226, can issue writs for fundamental rights and for any other purpose, which means legal rights. This makes the High Court the perfect constitutional body to review decisions on service matters, taxation, tenancy, and so on. If the High Court had been cut out of the picture, a huge number of disputes over ordinary legal rights would have been left with no constitutional review at all. It would have created a massive imbalance.
So Article 226 is the functional constitutional tool that makes the High Court the essential middle tier for tribunal review.
Absolutely. The Supreme Court understood that Article 226 is the primary constitutional safety valve against administrative overreach at the state level. Removing it would have crippled our system of checks and balances.
Let's bring this right up to the present day. The tribunal system, even after the 1997 ruling, keeps facing these structural challenges. The government has tried major restructuring, especially through the Finance Act. What does this tell us about the ongoing tug-of-war between the executive and the judiciary?
This is where the topic becomes incredibly relevant for a mains answer today. Since 2017, the government has repeatedly used the Finance Act, which is really a budgetary tool to merge, abolish, and change the appointment conditions for numerous tribunals under 323B. Things like the Income Tax Appellate Tribunal, the Copyright Board, and others.
Why use the Finance Act to do that?
Well, because money bills, which the Finance Act is, have fewer procedural hurdles to clear in Parliament. It's a faster legislative route. But the Supreme Court has repeatedly pushed back, striking down or modifying these legislative changes, most recently in cases related to the Tribunal Reforms Act of 2021.
And what was the main judicial objection to these restructuring efforts?
The objections are always about the same thing: preserving judicial independence, which is tied to the basic structure. The Supreme Court found that many of these new provisions tried to give the executive too much control over appointments, tenure, and infrastructure.
For instance,
setting very short tenures, like 4 years, or low age limits. This discourages independent candidates and gives the government leverage over reappointments, or putting the tribunals under the administrative control of the very ministry that is often a litigant before it, or watering down the qualifications required for members.
So this shows that the fight that was settled in L. Chandra Kumar on one level is still not over. The legislature and the executive are still testing the boundaries, and the judiciary is still defending that red line of the basic structure.
It's a perfect, dynamic illustration of checks and balances in action. The thematic depth here for you as an aspirant is this: how does the principle of separation of powers play out when the executive tries to reorganize specialized justice? The answer is clear. The Supreme Court, acting as the sentinel of the Constitution, steps in to ensure that administrative efficiency never comes at the cost of judicial impartiality.
So the ultimate takeaway here is that while creating tribunals was an act of legislative power for efficiency, the entire history of tribunals since then has been a story of judicial power defending constitutional integrity.
That tension is the central narrative.
Yeah.
You have to understand that the efficiency benefits of a tribunal are totally undermined if the quality and independence of the justice it delivers are compromised by executive influence. That's the bottom line. So, to quickly summarize our deep dive today, we started with that constitutional foundation from the 42nd Amendment. We have Article 323A for those very specific administrative tribunals, the CAT and SATs, which only Parliament can legislate on. And then there's the much broader Article 323B for tribunals across many other policy areas, which the appropriate legislature can set up. But the critical point, the game changer, was the Supreme Court in the 1997 Chandra Kumar case. It declared that judicial review is part of the basic structure, something that can't be amended away. And this mandated that all tribunal decisions must be subject to scrutiny by the High Court under Articles 226 and 227.
And remember, mastering the why, the reasons for their creation, the quest for speedy justice, the structural flaws in their composition, and that tension with judicial independence, that's what you need. Mastering that, alongside the how, the specific articles, the post-1997 hierarchy, the ongoing legal fights, is what elevates a strong UPSC candidate from a good one. You are studying a living, breathing piece of constitutional machinery, not just a list of bodies. If you've gained real insight from this deep dive and you feel more prepared for those critical mains questions, please do us a huge favor. Like this content, share it with your study group or your peers, and please leave a valuable comment detailing your biggest takeaway or maybe a concept that finally clicked for you today. It really helps us plan what to cover next. And a humble request once more. Please subscribe and join our learning family. If you're in a position to do so, joining our paid membership on YouTube is the absolute best way to directly support our work and help us keep providing this kind of high-utility material. A huge, heartfelt thank you again to all our existing members. You are the ones who make this in-depth content possible.
And a final reminder, don't miss out on those resources. The free notes with practice PYQs are on our Telegram channel, and for our Legend members, the premium notes with Model Mains answers are waiting for you on Discord. Go and apply this knowledge right away.
Finally, a provocative thought for you to think about as you prepare. We've established that the judiciary fiercely guards its right to review under the basic structure doctrine. But what happens in the future? When the biggest disputes are in highly specialized, fast-moving domains like AI regulation or complex international trade or intellectual property, which require decision-makers with deep, constantly updated technical knowledge, will the Supreme Court eventually need to evolve its definition of judicial independence? Can we design tribunals to be truly expert-led and fast while still keeping the spirit of judicial independence without being tied to traditional court structures? Is there a future where judicial review focuses only on major areas of law, trusting specialized expertise more fully? Something to consider as you prepare to lead the nation's policy future.